Good evening. It's 6 o'clock on a Thursday night, and I am Stephen Leskin. Welcome to this edition of Deep Dive. We'll spend the next 45 minutes or an hour or so talking about a divorce issue in depth. A little bit about me and the series. I've been practicing law in Portland in Oregon, actually, since 1992. I've been doing family law since about 2001. At this point in my career, I'm doing just exclusively family law and more and more mediation. The bulk of my practice is mediation at this point, even though I do still litigate a lot of cases. This series is intended to be a really focused hour on one topic, and uh, I try to do this not as an infomercial for me. That's not the intent. I will talk about myself and my practice, but it's in context of what we're talking about. If you have questions, you are more than welcome to send me an email. You're more than welcome to give me a call. Just tell me that you saw the deep dive. I don't take questions during the webinar because I lose my train of thought and then I say something, off-putting, or something like that, and I get bad reviews. So no questions because it just leads to a string of like catastrophe. Well, it's really not catastrophe in any event. So tonight's topic is all about mediation, and the name of the tonight's webinar is Deep Dive Mediation, a Better Alternative. And that's a true statement. Generally, mediation is a better alternative, but it's certainly not appropriate for everybody in every case. And I'll go through when it's appropriate, when it's not. So the format of tonight's agenda is we'll cover what mediation is, and what is alternative dispute resolution and what role that has in the courts. I'll talk about when and under what circumstances mediation is actually required. Uh, um, I will talk about when private mediation is not recommended. I'll talk about what happens in mediation and how to find a good mediator and actually just some considerations in looking for a mediator. Um, I had a conversation with somebody just today about mediation and realized that there are um, different times when a mediator might get hired. And I'll talk about that as well because that may impact how people think about litigation versus mediation. So I will start with that, litigation versus mediation. When I say litigation, I mean uh, you file a petition for dissolution and then the other person responds and their attorney is involved and you go through the process of exchanging voluminous amounts of personal data back and forth between the spouses and then you go through some settlement process. Maybe it's a judicial settlement conference at the court, maybe it's with a private mediator, maybe it's with a mediator that's provided through each of the counties. Each of the counties is required in Oregon is required to have some form of mediation available to divorcing parties. And I'll come back to that. And then finally, if you can't get an agreement, you go to trial. That's litigation. That process um, came about over years and years and years. And the process came about as a result of marriage being viewed as a contract. And if you wanted to get out of the marriage, you had to get out of a contract. And so you had to prove that there was fault. And so back in the day, and still in about 15 states, you still have to go to court and prove that there was infidelity or some other reason that you should have the divorce. And you could lose a case like that, right? You could find yourself driving home with your spouse saying, "Oh shit, we're still married," because you didn't prove your case. So I don't know how often that happens, but that is a distinct possibility that in a framework that requires fault. Oregon is no fault. Most of the states now are no fault, which means that you simply have to allege just the allegation that there are irreconcilable differences that lead to the irredeemable breakdown of the marriage. Just saying that is enough to get you divorced. You don't have to prove it even, and you can't contest it. right? So if I'm saying mad about my spouse, um, she can't come and say, no, we get along fine, right? So you get divorced in any case. So that's litigation with a little digression there. Mediation is two people speaking together through a third party who is a neutral. And the neutral's job is to help the parties come to a solution that works for the both of them. And a mediator generally will go back and forth between husband and wife or whatever the mediation is about and help the parties realize what their interests are and help them to realize where their interests lie, right? And that's mediation. And good mediator helps people get to that point so that they have a constructive win. Uh, there's a stupid saying that if both people come away unhappy, then it must be a good agreement. Dumb. I want people to come away like, yeah, we did the best we could, and this is the best we can do under the circumstances. And so that's what a mediator tries to do, is come to the best, help the parties come to the best resolution they can under their circumstances. Uh, and so mediation is a process of talking with your, in divorce context, is a process of talking with your spouse through a neutral third party who go back and forth uh, um, if people are in different rooms or all together in one room until there's a resolution. Uh, there's two other types of alternative dispute resolution. We talked about litigation, and now we talked about mediation. There's arbitration, which is not used too often in a family law context, but arbitration uh, brings the parties together with a neutral arbitrator who acts as a judge and makes decisions in the case. It's we'll still have opening statements and evidence and evidentiary rules. Maybe those are relaxed, uh, but it's going to be quicker and cheaper for people to do an arbitration often than going to trial. And sometimes attorneys will agree uh, to arbitrate a case. Um, you find arbitration more in like consumer cases or personal injury cases. You don't really see it so much in divorce. The last alternative dispute resolution uh, mechanism is a hybrid mediation, which is mediation and arbitration, right? It's hybrid. And this is what I do. And uh, um, so the parties will meet, they'll discuss, they'll go through the arbitration process. And if they can't get an agreement, then the mediator steps in the role of arbitrator and makes a decision on the outstanding issues. And that has the advantage of knowing that there's some finality at a limited time. With mediation, parties are not required to come to an agreement. Even if going to the mediation is mandatory, agreement is not. In fact, making a good faith effort to get to an agreement is all that's required. You got to talk to your spouse or partner for a little bit to demonstrate good faith, and but you do not have to, and there's no expectation that you will necessarily come to a mutually agreed resolution of your differences. Is mediation required? So mediation is a technique to resolve differences, right? And um, mediation may be required in Oregon in family law court. Mediation is required, and each county is authorized to set up their own rules for mediation. So you've filed a party has filed a divorce action, right? The petition for dissolution, and the other side's responded. And at that point, you'll generally get a letter. The parties generally get a letter from the court saying you're required to do mediation. Each court, each county is different. Some counties will only do mediation if they're children. Some counties will allow any issue. It just kind of depends on what the county requires. Uh, um, and then some counties will say, well, you will mediate on everything if you have children. So you can mediate on spousal support or distribution of property. Other counties are no, it's only limited to custody, child support, and parenting time. So kind of depends on which county you're in. Every county is different. Um, but that process is uh, universally required in Oregon unless the parties opt out of mediation. And the grounds for opting out is um, usually domestic violence. So if there's an abuse situation in the relationship, that would be grounds for the court waiving the mediation requirement. So mediation is not required where there's, abusive restraining order, for example, or stalking order, or menacing or something along those lines. Those parties are not required to mediate their differences. The long and short of it is mediation required in Oregon? It is in divorce, and the courthouses provide the mediator, and there's no cost for that. I should not say that categorically. In Multnomah County and the surrounding Tri-County areas, there's no cost. There may be some cost outside of the Portland area that I'm not aware of, but generally it's no cost. At that point, sometimes um, after if parties have two lawyers involved, a agreement may the parties may come to an agreement to hire a private mediator, right? And so private mediator will spend more time, is paid by the hour, and will work through the the um, the child issues, if there are any, the property issues, and um, uh, will help the parties achieve a resolution that way. There are lots of private mediators in Portland. It's becoming a popular way, a popular thing for attorneys to do. If you go online and type divorce mediators, Portland, Oregon, you'll see me, but you'll also see a lot of other people coming up. And it didn't used to be that way. Even 3 years ago, there weren't nearly as many private mediators as there are now. So private mediation is becoming more and more popular. I don't do mediation in context of court. So, and I'm only telling you this so that like you'll understand like the different types of mediation. There are mediators who will get called by an attorney and say, "Will you mediate the case?" I don't do that. I take cases where the parties haven't gotten divorced yet and they want to mediate their differences. So I get involved before um, before any of the paperwork is filed, and then I file it for people. So one thing to keep in mind is like at what stage of the divorce will you bring in a mediator? Uh, I think the best time is before you file, because that's just the most efficient. Um, some people will hire a mediator after or go to mediation after one side files or not. I tend to think that that might um, um, lessen the impact of the mediation because you know that you have an out, right? You know, well, the case is already filed. I don't agree with you. So, um, uh, filing after the divorce in context of the litigation, uh, it, the dynamic is a little bit different from when somebody hires me before they file for the divorce. So that's just something to keep in mind as well. Um, so that's kind of the parameters of when mediation. It's not kind of that is the parameters of when mediation is required and what it might look like in court versus a private setting. Um, when is mediation not recommended? So there are definitely things that will preclude or should preclude a couple from going through mediation. One of the obvious ones is mental incapacity. Uh, the mediation is going to lead to an agreement, and both parties need to be competent. And in the absence of competency, you don't have a binding agreement, right? Somebody can come back and say, you didn't have the capacity to contract. So, uh, uh, mental capacity, intellectual capacity, uh, is a requirement of mediation. If somebody calls and says, call on behalf of my dad who needs a divorce, and he's older, he's not competent anymore, but he has He has a big nest egg, and what do we do? The solution then is to create a guardianship for the dad, and uh, one of the kids, or well, it's going to be mostly the kids, will come in and step into the role of guardianship, and they'll have a duty of care to the father to negotiate on his behalf, and then can sign the divorce decree as the guardian. Um, Mediation is also not warranted when there are deep trust issues. So, for example, if you don't trust your spouse to disclose all of the assets or all of the liability or all of the debt, then mediation is not appropriate. Uh, at least the way I do it. If you're in court and so I do mediation before court. If you're in context of court and the attorney has used um, the discovery tools of requesting documents and subpoenaing documents and taking depositions, and even if you don't trust the spouse, you have a high degree of certainty that there's been a full disclosure. Then after that and everything is on the table, then you could certainly mediate. It may not, if you don't trust the spouse, it may not be really worth the time. That's another issue. Um, but you need to know that you're going to have a full accounting of all of the income, assets, and liabilities of the marriage. And if you don't trust your spouse to be straight with you, maybe one person has been doing all the bookkeeping, paying all the bills during the marriage, making all the financial decisions, making arrangements to get the taxes paid, and the other person is, well, they wouldn't let me do it, or I have no idea where any of this is, or I suspect that money's being diverted, then mediation is not really a good idea. So there's got to be some modicum of trust between the parties. And it's not really trust. If you know your spouse, you know your spouse's integrity, presumably, even if you're getting divorced, um, or lack of integrity, uh, or integrity on financial matters. Uh, if that's not an issue, then mediation is fine. But if there's some suspect dealings, or you think that there's money missing, or you don't know of all the bank accounts, or you've asked for information and you've not gotten it back. Like, for example, can I see the latest bank statements, and the spouse is reluctant to give it to you, then you're probably not going to want to mediate, because you will need the tools that an attorney will have in litigation to discover the assets, liabilities, or income that you're not otherwise getting, right? And like I said, the attorney has the power to subpoena records from third parties. So, for example, somebody's not giving up bank records. You can put them under oath at a deposition. Say, where do you do your banking? I do my banking, Bank of America. The attorney can then send a subpoena to Bank of America. The other side is practically powerless to do anything about that. So that's one way to um, ensure that all of the financial assets and whatnot are on the table. So that would be the second criteria for disqualifying criteria for whether or not mediation is appropriate. The first is mental incapacity, intellectual incapacity. Second is um, lack of trust in the person's willingness to disclose all of the assets and liabilities. The third uh, area where you should think carefully about whether or not you want to mediate is where there's been abuse or domestic violence. I um I am of two minds, and every person needs to make their own decision about this. Like, on the one hand, when I act as a mediator, the only thing I'm bringing back and forth between the parties is the proposals. So I'm acting to make sure that other undue influences are not at work in the negotiations, right? So I work to keep um, the personality issues separate from the business issues, right? And um, it takes a strong personality to be able to do that and to stand up to somebody who's bullying, or a narcissist, or um, just, you know, being problematic. And you need to have that feel for whether or not the person you're going to hire to mediate has that kind of strength of personality, and experience. And if so, if you're in that kind of domestic violence situation or abuse situation, uh, you're not necessarily going to be in the same room when you mediate. Um, you could be in different rooms. You could be in different Zoom breakout rooms. So you're not confronting your abuser, uh, but they still may exert some power over you. They may be able to send you messages that the mediator just is not privy to the meaning of. Uh, so the alternative in those situations is um, litigation. And, like I said at the outset, litigation is going to be more expensive. But on the other hand, you're buying the loyalty of a competent attorney who will, represent you and give you their best advice over, how to get where you want to go. I found that over the years, a lot of times people come into it like, I'm not going to get pushed around anymore. Uh, um, I need an attorney to protect me, and they can't get through where the abuse has been particularly painful. Litigation itself becomes abusive, right? There's, you know, request after request, and attorney fee after attorney fee, and invoice after invoice, and that just becomes abusive and unbearable. And a lot of times, people in an abusive situation will fold at the end. It's like they're just like, it's not worth it, right? Or, I will accept significantly less just to be done with the process. And sometimes that's okay. Sometimes that's, a rational decision. Uh, but other times, it's not. And it's not because the divorce is also about financial planning for the future. And if you have a small estate, small marital estate, and you're young, you're going to build back in any event. It doesn't matter as much. But if you're an older person and you just want to be done and you're willing to give up, your retirement accounts or the family retirement accounts has to be done, there's something wrong with that. And as an attorney who's been in that situation many times, it's heartbreaking, and you don't want to see people uh, do that. Um, and so maybe for some of those people, mediation would be better because it's a shorter process. They have a little bit more control. You can still attend mediation with an attorney, right? So you can still hire an attorney if you have the resources to do that. So uh, the individual needs to do an assessment about where they think they're going to find their strength the best to represent themselves, even with the attorney, uh, to get the best outcome for themselves and not end up as I just want this to be over. So um, that's the third area that might disqualify somebody from mediating, or at least should question whether or not mediation is the correct venue for them. And then finally, lastly, is a couple that has uh, significantly complex financial instruments. Like there's lots of options or other financial um, assets that are difficult to understand and difficult to divide. And there may be attorney mediators out there who are comfortable with that, but you need to know how um, those assets divide in context of a divorce. And um, while attorneys have pretty good general knowledge of financial instruments and things like that, the really complicated stuff that big corporations give to employees um, require certain expertise. And so either there's got to be a willingness to pay for help to bring the attorney up to understanding, or um, um, you need to hire somebody with, a mediator with that kind of specialty, with that kind of special knowledge. I'm here to tell you that's not me. I mean, I got the basics down, but once you're starting to get into derivatives, for example, or options, um, it's financial information that I'm not. I need to hire out when I have a case like that. I need to hire out and bring in expertise to help me understand those instruments so that I get it right. And that's not that unusual, but that is something to consider. So that's that's when mediation is not warranted under those couple of circumstances. So let's switch gears a little bit. What happens at mediation? So uh, every attorney does things, every mediator does things differently, and there's different types of mediators and um, different mediation styles. I'll talk about that in just a second. Uh, but generally, what happens, I mean, this is going to be universally true, is that um, the mediator will go back and forth between a couple and will act as an impartial umpire, impartial neutral to help the parties come to an agreement. Sometimes the mediator is in the same room with the parties. Sometimes the mediator is shuffling back and forth. Like I said, sometimes on Zoom, it's in different breakout rooms. But the crux of it is always going to be that the mediator is attempting to help the parties get to where they need to be, which means get to a settlement. Um, there are different styles of mediation. There's one style called transformative, and in that style of mediation, the mediator is helping, trying to get people to have a breakthrough and get to like a kind of core understanding and core resolution that goes deeper than just their um, stated differences. And maybe there's yelling, maybe there's crying. That's not my style. I don't do transformative. That's not my business. It's not my place. There's another form of mediation called narrative, where you're trying to identify people's interests and helping them get to, deeper understanding of what their actual interests are to achieve an outcome. There's and then there's my style of mediation, which I uh, call muscular mediation, and that's I want the people who are mediating with me to understand what Oregon law is. I want them to have the guidelines of Oregon law so that when they're mediating together, they have a sense of what's fair and what other couples uh, will do if they go to court and what a court outcome might look like. And I've found over the years that once people understand what the law is, it's much more easier for them to come to an agreement because they have a framework for understanding and they know that they're going to be within the ballpark of what other people are going to get. They don't have the same worry that they're going to get taken advantage of once both parties have the same explanation of Oregon law. And so my style is I will give people Oregon law, I will explain it to them, and then help them to fashion their um, agreement along those lines. And so I may take a little bit more active approach than somebody who does transformative or the narrative type of mediation. Um, but that's my goal, is that I want people to know what Oregon law is. Uh, the other thing that I do that other mediators don't do is that by the time we get to mediation, I don't want to have factual disputes. I don't want to be arguing about how much. I don't want to go to mediation and argue over how much is in a bank account. I want all of that to be worked out before we get to the mediation. And so my process involves a pretty comprehensive pre-mediation conference to figure out, do we have all the assets on the table? What are their values? So if it involves it involves multiple bank accounts and they're going to be divided, I want to know that at the time of the mediation, we're all on the same page and all know what the values are of the bank accounts or the credit cards or the house or whatnot, so that we can apply Oregon law to those agreed facts to come to a resolution. So my style of mediation is more muscular than most mediators, and I'm a little bit more actively involved in helping people to fashion a settlement using Oregon law as guidelines. So um, that's what happens at mediation. It's talking. It's bringing people together to talk about their differences. The last thing I'm going to cover tonight is going to be a little bit shorter session than usual, but the last thing I'm going to talk about tonight is how to locate a good mediator. And something that people don't consider is like what's the role of the mediator going to actually be? So if you're like mediating through um, court, like you're going through court mandated mediation. It's not a private mediator. The court's helping parties out. the court staff, their job is to help you get to an agreement, and they may help you fill out the paperwork um, to get the judgment signed by the court, right? So, uh, or sometimes they'll just do a statement that the parties agreed to this, this, and this, and then it's up to the parties to get the paperwork signed, completed, and then signed. So that's the first thing to consider with the mediator. Is it? That's what happens with the courts. If you're hiring a private mediator, who's going to do the paperwork? Who's going to do the court documents? And so sometimes I do it. Like if you hire me as a mediator, I do all the court documents. But that's not always the case. There are many, many mediators in town who will have that part of the case farmed out to a paralegal. And um, you know, presumably the paralegal is going to be competent, but it's not going to be the attorney or the attorney that you mediated with. So that's one question. The other question is there are uh, dual professional mediators, right? There's very rare are there family law. There are, but people who just do mediation. Usually, it's a therapist or clergy person or an attorney who's conducting the mediation. And the question is that specialty person right? Um, I get a little unnerved when I see like, particularly like, religious people doing um, mediation who aren't otherwise trained in, the subject area of divorce law. And so, um, my recommendation, of course, is going to be to hire like a family law attorney who does mediation, not a therapist who does family law. You're ultimately talking about a court process and something that has to go through the court. And so, there are therapists out there who will mediate and, get a resolution. But ultimately, the test is whether or not the document's going to hold up when there's conflict on it in the future, right? You're not only thinking about today, you're thinking about what's going to happen 5 years from now, what's going to happen 10 years from now. And the things that need to be in the judgment to anticipate that are just born out of experience and knowledge of the law. And so you need to think carefully about, uh, you don't need to do anything. But my recommendation is that you think carefully about what type of person, professional do you want to do the mediation. Um, so if you're comfortable with somebody, you're comfortable with your therapist, and the therapist is willing to do the mediation with you and your spouse, great. But then the question still is who's going to do the paperwork at the end to get it through the court. Um, but the other part of it is, they're not going to be as familiar with family law as maybe they should, and maybe that's going to create problems down the road. So um, that's just something to consider. And if you're talking to people, just ask them about that, right? Who's going to do the judgment? How do I know the judgment's going to hold up? The court will sign it now, but what's it going to look like, 5 years from now, right? What's built in to reduce conflict going forward, particularly if the kid's involved. And even at that, you can always come back and modify a divorce decree, and it's expected that that will happen in terms of the kids because the kids change um, and grow and mature. Uh, but you still want somebody who can anticipate where there are going to be future problems, and that's what a good attorney does. Um, so um, the other two questions are cost is knowing how a potential mediator is going to bill. Is it going to be by the hour? Is it going to be, set fee? Is it going to be sliding scale? So you need to, talk to the mediator and figure out what the costs are going to be. I don't really know what other attorneys do. I think most people charge by the hour, and so you could enter into an open-ended representation agreement with the law office for $400 an hour or more, and then still not get an agreement. And maybe you're crossing items off the list, but you're still eventually ending up in court, and court time is always expensive. It's always time consuming, and it's always just risk. It always will have risk because you don't know what a judge is ultimately going to do. So um, that's another consideration is just how the mediator will bill for time. I do it on just by contrast, I do it on a flat fee. on a sliding scale depending on how much assets are in the marriage. And I have, a fee calculator, which is on my website, and that's what I charge. And then I do all of the um, drafting included in that. So knowing how much it's going to cost, who's going to pay for what services, what's going to happen if there's a retirement account, if there's a 401k that needs to be, or a pension that needs to be divided, that's always going to cost extra. Who's going to cover those costs, or who's going to cover the filing fee? So those are all things that you want to nail down with a potential mediator and an attorney too. Um, I when people call me up and say, I'm looking for a mediator, I'm happy to talk to people. Um, I want people to be comfortable with me. I want people to know what I'm about. I want people to know what my experiences are. So, and I don't charge for that. Other people charge for that. I don't. So you want to see, how comfortable are you talking to somebody? How well do they communicate with you? What kind of rapport do you have with them? Because ultimately, mediation is about rapport, and trust, and being able to work with people to help them at a difficult time to come to a good resolution. I think that covers it. That's all I have for tonight. Um, Again, if you didn't get it the first 8 times, my name is Stephen Laskin, and I am a divorce attorney in Portland. My website is leskinlaw.com. It's leskinlaw.com. I'm happy to take calls. Please feel free to give me a call tomorrow, or send me an email next couple of days if you watch and you have questions and you want to go over something. I'm really truly more than happy to do that. So it is about, what time is it? It is about 40 after. So that's usually pretty close to my usual time, about 45 minutes. So thank you for watching tonight. Thank you for joining me. And please, like I said, I mean, genuinely, if you have questions, please feel free to give me a call or reach out to me. And this webinar will be up on my website in the next couple of days. And you'll find my other deep dive seminar talks on there as well. Coming up, I will say that the next session in 2 weeks is uh, negotiating with a narcissist. I've given this talk a couple times on how to deal with narcissist personality types, and I personally know how challenging that can be. Not that I am one, but that they come across my desk pretty for uh, recently. A month from now, we'll be doing a talk on basics of Oregon law, so basics of Oregon divorce law. So if you wanted an overview of Oregon divorce law, that would be a great seminar. That will take almost a full hour, and I will cover the three general categories, not in any depth, but the three general categories, which is division of property and liabilities, uh, the kids, which is custody, child support, and parenting time, and finally spousal support. And so I'll do overview of each of those topics. And then finally, oh, hold on, I gotta put on my glasses for this. Jeez, I'm getting old. And then finally, uh, a month from now, I'll be doing a series on picking a good divorce lawyer. And I will share some of my experiences with you. So thank you for watching. It's been a great audience tonight. You're wonderful people. A credit to your species. And I'm glad we could spend this time together. Thank you.